New York has one of the most complex and tenant-protective lease termination frameworks in the entire United States, and it became even more restrictive with the passage of the Housing Stability and Tenant Protection Act of 2019. If you own rental property in New York, especially in New York City, understanding these laws is absolutely critical because the consequences of getting it wrong are severe. New York's lease termination framework is found in the Real Property Law, the Real Property Actions and Proceedings Law, and for New York City specifically, the Rent Stabilization Code and the Housing Maintenance Code. The 2019 reforms overhauled large portions of these laws, and what landlords could do before 2019 may no longer be legal today. Let's start with the most important change. New York now requires just cause for most evictions statewide. Under the 2019 reforms and subsequent legislation, landlords must have a legally recognized reason to terminate a tenancy. For rent-stabilized apartments in New York City, which account for a massive portion of the city's rental housing, the just cause requirements have been in place for decades. But the 2019 law extended similar protections more broadly. For month-to-month tenancies outside of New York City, the notice requirements depend on how long the tenant has been in occupancy. If the tenant has lived in the unit for less than 1 year, the landlord must provide at least 30 days written notice. If the tenant has been there for 1 to 2 years, the notice period increases to 60 days. And if the tenant has been there for 2 years or more, the landlord must provide at least 90 days written notice. These staggered notice periods were a major change introduced by the 2019 reforms and apply statewide. For tenants, the same staggered notice periods apply when they want to terminate a month-to-month tenancy: 30 days for less than 1 year, 60 days for 1 to 2 years, and 90 days for 2 years or more. For fixed-term leases, the lease expires at the end of the agreed term. However, the landlord must still provide advance notice of non-renewal based on the same staggered timeline: 30, 60, or 90 days depending on the length of occupancy. If the landlord fails to provide this notice, the tenant has the right to remain beyond the lease term, and the tenancy effectively continues. Now let's talk about New York City specifically, because the rules there are significantly more complex. For rent-stabilized apartments, the landlord must offer the tenant a renewal lease between 150 and 90 days before the current lease expires. The tenant has 60 days to accept or reject the renewal. If the landlord fails to offer a renewal lease, the tenant's lease is automatically extended on the same terms. Refusing to renew a rent-stabilized lease without a qualifying ground, such as owner occupancy or building demolition, is illegal. For non-rent stabilized apartments in New York City, the statewide notice requirements apply, but the city's housing court has its own procedures and timelines that add additional steps to the process. For termination for cause, let's start with non-payment. New York requires the landlord to make a demand for rent before filing a non-payment proceeding. Under the Real Property Actions and Proceedings Law, the landlord must serve a 14-day rent demand, giving the tenant 14 days to pay. The demand must specify the amount owed, the period covered, and the name and address where payment can be made. If the tenant pays within the 14 days, the demand is satisfied. If the tenant doesn't pay, the landlord can file a non-payment petition in court. The 2019 reforms also changed how courts handle non-payment cases. Courts now have greater discretion to grant tenants additional time to pay, and the availability of rental assistance programs has added another layer to the process. Judges may adjourn cases to allow tenants to apply for assistance, which can extend the timeline significantly. For lease violations, New York requires the landlord to serve a notice to cure before filing a holdover proceeding. The notice must identify the specific violation, describe what the tenant needs to do to correct it, and provide a reasonable time to cure, typically 10 days or as specified in the lease. If the tenant cures the violation, the landlord cannot proceed. If the tenant doesn't cure, the landlord can then serve a notice of termination, which must provide an additional period before the termination takes effect. and then file a holdover petition in court. This two-step process, notice to cure followed by notice of termination, is a common source of mistakes for New York landlords. Skipping either step or getting the timing wrong will result in the case being dismissed. Courts scrutinize these notices carefully, and even minor defects can be fatal to the landlord's case. For repeated violations of the same type, New York allows the landlord to serve a Golub notice, named after the court case that established the procedure. A Golub notice warns the tenant that the landlord considers their repeated violations to be a substantial breach of the lease and may seek non-renewal. This must be served well before the lease expiration, typically at least 30 days, and the landlord must then follow up with a termination notice based on the pattern of violations. For serious violations, including illegal activity, creating a nuisance, and using the apartment for illegal purposes, New York allows the landlord to pursue eviction through a holdover proceeding. However, even in these cases, the procedural requirements are strict. The landlord must serve proper predicate notices, and the tenant has the right to appear and contest the allegations in court. New York City's housing court is a specialized court that handles the vast majority of residential eviction cases in the city. The court is extremely busy, with hundreds of thousands of cases filed annually, and the process can be lengthy. From initial filing to final resolution, a contested eviction case in New York City can take several months, and in some cases, a year or more. Landlords need to plan for this reality and budget accordingly. Outside of New York City, eviction cases are typically handled in city court, town court, or justice court, depending on the jurisdiction. The process is generally faster than in the city, but still requires strict compliance with notice and procedural requirements. The 2019 reforms also eliminated some of the tools landlords previously used to manage problem tenants. Landlords can no longer include lease provisions that waive the tenant's right to a jury trial in eviction proceedings. Personal liability clauses that hold guarantors liable beyond the lease term are restricted, and the amount landlords can collect as a security deposit is now capped at 1 month's rent statewide, meaning landlords can no longer require large upfront deposits to offset risk. On the tenant side, New York provides extensive grounds for early termination. Tenants who are victims of domestic violence can terminate early under Real Property Law Section 227-C by providing written notice along with documentation such as a valid order of protection. The tenant must provide at least 30 days' notice, and the landlord cannot charge early termination fees. New York also provides early termination rights for tenants who are 62 years of age or older and need to relocate to a residential care facility, adult care facility, or similar housing. The tenant must provide 30 days' notice along with documentation. Tenants can terminate if the landlord fails to maintain habitable conditions. As we covered in our New York habitability video, the implied warranty of habitability under Real Property Law Section 235-B gives tenants significant leverage. If conditions are seriously deficient, the tenant can terminate the lease based on constructive eviction. Active duty military members are covered by both the Federal Service Members Civil Relief Act and New York's own military law, which provides additional protections, including the right to terminate early with 30 days' notice following deployment or permanent change of station. New York strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove belongings, or take any action to force a tenant out. Under Real Property Actions and Proceedings Law Section 768, a tenant who is illegally locked out can bring a proceeding to be restored to possession and recover damages. The penalties for illegal eviction are severe. Landlords face civil liability for actual and punitive damages, and in some cases, criminal prosecution. New York City has specific criminal penalties for illegal lockouts, and the city has actively prosecuted landlords who engage in harassment or self-help eviction tactics. New York requires landlords to return the security deposit within 14 days of the tenant vacating the property. The landlord must provide an itemized statement of any deductions. Under the 2019 reforms, the deposit must be held in an interest-bearing account, and the tenant is entitled to the interest earned minus a small administrative fee. Failure to return the deposit within 14 days can result in the landlord losing the right to claim deductions and owing the tenant the full deposit amount plus penalties. For the complete guide to New York lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel so you stay protected in every state.